Hello students, today we will be talking about protection of women's rights under the international laws. The traditional concept of international law was basically envisaged as a law governing the conducts and relations of sovereign states with each other. However, during the passage of time, the concept of international law has gone a sea change, most particularly in the United Nations. Prior to the adoption of Charter of UN, the global community could not determine the rights and duties of individuals belonging to sovereign nations. Today, the Charter of the UN has become the main source and the basis for the legality of global initiatives and measures giving space to individual rights. It is worthy to note that individuals have now become the subject of international law rather than mere objects of it. As a result of the contemporary development in the field of international human rights, humanitarian and refugee laws. Therefore, the rights of women along with those of men have not only been recognized and guaranteed by the domestic legal system, but also found to be de jure recognized. What do you mean by de jure? By law, recognized and protected by the international law as well. International human rights law, international humanitarian law and refugee law contain specific provisions for protecting rights of women, which comprises various conventions and treaties among states binding themselves to obligations imposed by them for safeguarding the rights of women and to take up steps and measures for protecting women through legislation and other adequate measures in consonance with the international law. Now let me talk about international human rights law. Human rights and fundamental freedom is the birthright of all human beings that everybody knows. Their protection and promotion are the foremost responsibility of both the global organizations and the member states. Though protection of women's rights is ensured in the Universal Declaration of Human Rights, which is called UDHR, which was established in 1948, and the two sister covenants of 1966, the issue of women's rights still remain to be one of the disturbing areas. Women's human rights, despite the fact that international law guarantees women and men equal rights in the enjoyment of all human rights, women continue to face de jure, that I said earlier, in law, and de facto, that is in practice, inequalities in virtually all societies. In addition, armed conflict, natural disasters often exacerbate the discrimination and inequalities, further impeding progress towards gender equality and the full enjoyment by women of their human rights. Now, what does it show? This shows that there exist certain flaws, as the existing international laws have not been able to overcome bias and discrimination and to protect distinctly women's rights. Therefore, we evolved something like the Convention on the Elimination of All Forms of Discrimination Against Women. It's called the Convention on the Elimination of All Forms of Discrimination Against Women, which is called CEDAW, CEDAW. This was adopted in 1979. to reinforce the provisions of the existing international instruments aiming to eliminate discrimination against women and achieve gender equality. Till date, it has been ratified by 186 states, which is a happy news. Despite being the subject of mere reservation than any other human rights treaty, the significant number of ratification is expression that international community considers that discrimination against half the world's population is unacceptable and should be eliminated. UN and other actors should build and promote this international legal consensus in their work, not only in peace times but also during conflicts and disasters. Now, what does CEDAW define? CEDAW defines discrimination against women as any distinction, exclusion or restriction made on the basis of sex, meaning whether you are a woman or a man, which has the effect or purpose of impairing or nullifying the recognition enjoyed or exercised by women, irrespective of their marital status, on a basis of equality of men and women, of human rights and fundamental freedom in the political, economic, social, cultural, civil or any other field. It imposes obligation on states to inter alia embody the principles of equality of women and men in their national constitution, and legislation adopts legislative and other measures prohibiting discrimination against women, effectively protect women against any act of discrimination and provide opportunities for recourse, take measures to modify social and cultural patterns that contribute to discrimination against women. Then it suppresses prostitution and trafficking of women and ensures equality in political and public life, nationality laws, education, employment and labor rights, access to health, finance, social security, legal and civil matters and family law. It permits states to adopt temporary special measures to achieve equality. Now, becoming a party to CEDAW, a state is legally obliged to take all appropriate measures to eliminate discrimination against women and advance gender equality. Now, Article 2 makes clear that the state not only has the obligation not to discriminate through its own actions, but also to prevent and eliminate discrimination that is perpetuated by private individuals and organizations. The state's obligation extends to private life as well as public life. Article 16 provides that states must eliminate discrimination against women in marriage and family life, areas considered by many countries to fall within private spheres. Historically, one of the biggest obstacles to realizing women's rights in many countries has been the perception that the state should not interfere in the private realm of family relations. CEDAW recognizes that unequal power relations within the private sphere contribute very significantly to gender inequality in all aspects of women's lives and to direct states to take measures to correct this power imbalance. And this they do by accepting the convention. States commit themselves to undertake a series of measures to end discrimination against women in all forms, including to incorporate the principle of equality of men and women in their legal systems, abolish all discriminatory laws and adopt appropriate ones prohibiting discrimination against women. They have to then establish tribunals and other public institutions to ensure the effective protection of women against discrimination and to ensure elimination of all acts of discrimination against women by persons, organizations or enterprises. In addition to human rights treaties, several UN resolutions and world conferences have sought to strengthen the protection and promotion of women's human rights. These include the 1993 World Conference on Human Rights, which affirmed the universality of women's rights as human rights, stressed the importance of eliminating violence against women and specially recognized violence against women in armed conflict as a violation of human rights and humanitarian law. The 1993 Declaration on the Elimination of Violence Against Women furthermore emphasized that violence against women and girls is not only a grievous human rights abuse in itself, but also a serious impediment to the realization of many other rights for women and girls. The 1995 Beijing World Conference on Women includes strategic objectives to address the impact of armed conflict on women. UN Security Council Resolution 1325 also reiterated that civilians, particularly women and children, account for the vast majority of those negatively affected by conflict and called for measures to ensure that women are more equally represented in all stages of peace processes. It furthermore called on all parties to armed conflict to fully respect international law applicable to the rights and protection of civilian women and girls. In particular, the 4 Geneva Conventions of 1949 and 2 additional protocols of 1977, the Refugee Convention of 1951 and Protocol of 1967, the human rights instruments including CEDAW and its optional protocol of 1999 and the Committee on the Rights of Child, which is called CRC, and its 2 optional protocols of 2000, the Council cautioned all parties to armed conflicts to bear in mind the relevant provisions of the Rome Statute. The crime of genocide, crimes against humanity and war crimes fall within the jurisdiction of International Criminal Court, which is called ICC, which can hold individuals criminally responsible and punishable for committing acts amounting to these crimes. I would like to talk a little bit about International Humanitarian Law, which is called IHL. Now, IHL is a set of international rules established by treaties or custom which are specifically intended to solve humanitarian problems directly arising from international or non-international armed conflicts. Most important international treaty providing protection to women is the Protocol addition to the Geneva Convention of 12th August 1949 and relating to the protection of victims of international armed conflicts, Protocol 1, 8 June 1977. Now, there is a specific protection. What is it? The specific protection regime for women under IHL relates primarily to women's distinct health, hygiene and psychological needs and role as mothers. The aim of these specific provisions is to provide additional protection for women in response to their particular medical and physiological needs and for consideration of privacy. This is very important. Protection against sexual violence. IHL expressly protects women against rape through Article 27(2) of the 4th Geneva Convention, which reads, and let me quote, it reads like this: women shall be especially protected against any attack on their honor, in particularly against rape, enforced prostitution or any form of indecent assault. Quotes closed. Now, since the word honor did not reflect the full brutality of the act of sexual violence, which is not merely an attack on women's modesty or chastity, but on her physical and psychological well-being, the additional protocols replaced it with the term dignity. In addition, it is well established that sexual violence falls within the prohibition of cruel treatment or torture in the Geneva Conventions. Women deprived of their liberty. International humanitarian law contains specific protection for women deprived of their liberty, requiring separate quarters and sanitary conveniences for women unless women and men are accompanied together as members of the same family, and stipulating that women must be held under the immediate supervision of the female guards. Sex is also considered a relevant consideration in the determination of disciplinary punishment and in the labor of prisoners of war. Expectant mothers and maternity cases. There is a whole range of provisions that deal with expectant mothers, maternity cases and mothers of children under 7 years old. Interned expectant and nursing mothers are to be given additional food in proportion to their physiological needs, and interned maternity cases have a right to be admitted to institutions where they can receive adequate medical treatment. In terms of physical safety, parties to armed conflict are encouraged to adopt practices to ensure the physical safety of pregnant women by establishing safety zones for pregnant women and mothers of young children. Preservation of family links. Women are the main initiators of requests for news of family members bearing the emotional and economic burden of missing loved ones. Such women often lack a clear legal status under national law, which is not being recognized by the law either as wives or widows, and may have no right to access pensions or other entitlements. In an attempt inter alia to address such issues, IHL seeks to preserve and restore family unity by preventing the separation of family members against their will, requiring the adoption of measures that facilitate family reunification and laying down measures aimed at facilitating the re-establishment of family ties through correspondences and transmission of information. Now I will be talking about international refugee law. International refugee law is the branch of international law that deals with the rights and protection of refugees. The main principles of refugee law are set out in the 1951 Convention relating to the status of refugees and its 1967 Protocol, which sets out the general definition of a refugee and guarantees refugees a number of rights specific to their status. Now, the 1951 Convention defines a refugee as someone who is outside his or her country of origin or habitual residence and is unable or unwilling to return there owing to a well-founded fear of persecution on the grounds of race, religion, nationality, membership of a particular social group or a political opinion. Gender in this case can both influence and dictate the type of harm suffered. While women, girls, boys and men will often suffer similar harm, women and girls are often the main targets of violence and abuse because of their gender. For example, women and girls are more likely to suffer rape and other forms of gender related violence such as dowry related violence, coerced family planning, female genital mutilation, family domestic violence and trafficking. Such acts, whether perpetuated by a state or a non-state actor, can support a claim to refugee status. Asylum claims may also be based on discriminatory acts amounting to persecution, persecution on account of one's sexual orientation and trafficking for the purpose. The 1951 Convention guarantees refugee women, girls, boys and men a range of rights and freedoms and stipulates the treatment they are entitled to by the country of asylum. Now, what does it include? The right, first of all, to seek asylum. Then, the right not to be returned to the country where the refugee's life or freedom would be in danger. Number 3, the right to non-discrimination. The right to documented and to access work and education. And the right to freedom of movement, to access courts and practice one's religion. Humanitarian and human rights workers working for refugees and asylum seekers play an important role in identifying, preventing and responding to gender-related protection risks. This may include ensuring that asylum procedures are gender sensitive, guaranteeing that those suffering violation have access to and are referred to the proper authorities, whether national agencies, international organizations such as United Nations High Commissioner for Refugees, which is UNHCR, or non-governmental partners, assuring the provision of counseling and medical care as the circumstances require, preserving evidence and the confidentiality of any information, and ensuring proper follow-up of the case by the relevant authorities or agencies, guardians and legal representatives. In particularly serious cases, women and girls may need to be assisted in relocating within the country or resettling in a third country in order to ensure their safety. International humanitarian law and international human rights law and refugee law share a common goal in aiming to prevent and relieve sufferings and to protect the rights and freedom of women, girls, boys and men. As such, they complement and reinforce each other, thus providing a comprehensive framework of international law for the protection of men and women. Now, these three branches of law are, however, different in both their applicability and scope. Humanitarian law is specific to armed conflict, while refugee law only applies to refugees and asylum seekers. Human rights law is broader and applies to all human beings during times of both peace and war. The guarantees offered by the different branches of international law are mutually reinforcing, thus enabling humanitarian and human rights actors to maximize the protection offered to women. In some situations, they will overlap and a determination should be made on how to apply them to secure greatest protection for affected population. Now, let me conclude by saying this brief statement that despite the fact that international laws guarantee women and men equal rights in the enjoyment of all human rights, women continue to face de jure, that is in law, and de facto, that is in practice, inequalities in virtually all societies. In addition, armed conflict and natural disasters often exacerbate discrimination and inequalities, further impeding progress towards gender equality and the full enjoyment by women of their human rights.